Welcome to The Explainer. Today, we're taking a deep dive into something I guarantee you did this very morning without even thinking twice about it. I'm talking about that everyday act of just clicking I agree or I accept on a website or an app. I mean, it feels like a completely harmless little click, right? But as you'll see today, that tiny digital action actually carries a massive, hidden legal weight that, honestly, most organizations are completely ignoring.
Okay, let's dive into this. Could clicking I agree actually trigger a massive tax penalty? I know, it sounds almost like a prank, but trust me, this is a very real legal risk right now. We are literally witnessing a bizarre collision between the modern digital handshake of online consent and a centuries-old financial concept. I'm talking about stamp duty. So to understand exactly how we got here, we really have to look at the mechanics of how we agree to things online.
Now, in the industry, we call this click-wrap consent. Basically, it's just the digital method of recording your agreement to a set of terms, usually by just hitting an I accept button. And hey, it's incredibly convenient. In the real world, a contract needs a physical ink signature to be rock solid. But online, we trade that ink for convenience. The problem is, under current Indian laws, specifically the Information Technology Act of 2000, this everyday method is navigating a massive legal gray area. Why? Well, because a simple button click isn't technically a formal electronic signature.
Section 1. Evolution of digital signatures.
So let's look at the timeline here. Back in 1999 and 2000, India was actually a pioneer. We were one of the early countries to adopt a mandatory digital signature system when the Information Technology Act 2000 was enacted. But there was a catch. The law prescribed digital signatures, what we now call electronic signatures, as the absolute only means of authentication. This meant that an electronic document without a proper, formal digital signature couldn't be considered legally signed for contractual purposes. Now, early on, this wasn't really a huge tax issue. Electronic documents were largely interpreted as exempt from stamp duty simply because, well, there just wasn't a viable physical way to stamp a digital file. But as you can see, the laws kept evolving step by step all the way up to our recent data protection acts.
So because a simple click wasn't technically a signature under the IT Act, it created what we call an authentication gap. Over time, new solutions were introduced. The Aadhaar-based e-sign made it a lot simpler to obtain legally acceptable consent online. But it's not perfect. It comes with financial costs and definitely raises some privacy disclosure issues. Because of this, experts like Naavi have actually suggested alternatives, such as using a CEAC Dropbox. You can think of this kind of like a secure, independent digital vault. A record of your consent is safely deposited there and time-stamped, confirming your agreement without relying on expensive third parties.
Section 2. The Stamp Duty Dilemma.
Which leads us to a pretty critical question. How exactly do you stamp a virtual digital document? It's kind of a fascinating historical puzzle when you think about it, trying to apply a physical adhesive tax to a sequence of ones and zeros. Over the years, as e-governance really advanced, state governments started to realize they were missing out on a lot of tax revenue. So they began passing laws mandating the payment of stamp duty even on electronic documents.
Now, we all know the old world of physical adhesive stamps, but what's truly fascinating is the proposed new world that almost happened. Back in the early days, way before UPI even existed, an expert named Naavi introduced an incredibly innovative hybrid system called the Digital Value Imprinted Instrument System, or DVIIS. Basically, it combined back-end digital value creation with a hybrid coupon that you could actually affix to an online contract, allowing you to pay stamp duty completely online. It was even presented to the stockholding corporation, but fascinatingly, it was rejected in favor of an alternative foreign system. It really remains a deeply interesting missed opportunity in our early digital governance.
And the thing is, this stamp duty issue doesn't just affect final contracts. It affects preliminary agreements too, like an MOU or Memorandum of Understanding. Often, this is just considered a documentation of intention. A lot of organizations think, well, an MOU isn't legally enforceable in a court anyway, so we're totally fine. But here's the catch. Even if you never go to court, failing to stamp an MOU can trigger strict penalties from authorities. It basically turns into a severe internal compliance issue.
Section 3. When data meets taxation. Now, what's really interesting about this slide is the new Digital Personal Data Protection Act of 2023, or DPDPA. It explicitly recognizes that personal data has a property nature. Basically, it can be monetized. And because of established monetization practices, personal data assets have clear, undeniable financial value. Therefore, in a privacy contract where a notice asks for permissions to use your data, there is an actual underlying financial value to that agreement.
And because of that value, your simple I accept click is now legally considered an electronic document that absolutely requires the payment of stamp duty.
So let's walk through how a business could accidentally fall right into this hidden trap. It starts simply enough, right? Step 1, a user gives their click wrap consent on your website. Step 2, your company begins monetizing that personal data. Everyone is happy. Until step 3, a dispute arises. The data principal raises an issue claiming compensation. Suddenly, step 4, the adjudicator looks at your records, sees the consent wasn't officially stamped with a duty payment, and immediately demands that stamp duty plus a penalty.
And guys, here is the absolute climax of this legal trap. If a dispute arises, the stamp duty authorities can demand a massive penalty of 10 times the normal stamp duty on those agreements. Let me say that again, 10 times. And worse, that penalty can be directly linked to the financial value of the underlying data on which the dispute has arisen. It is just a staggering financial risk for a simple digital button.
So, the crucial point here is that if an organization falls into this trap, their consent record becomes what the law actually calls an infructuous document. Because it lacks a formal digital signature under the IT Act and because it lacks the required stamp duty payment, the document is considered completely void. It is legally useless. It's literally as if you never had a contract at all, leaving you with absolutely no legal proof of consent.
Section 4, Fixing the Legal Glitch. So, how do we fix this? Well, there are two major legislative amendments required from the government to finally remove this ambiguity. First up, the Ministry of Electronics and Information Technology, or MIT, really needs to amend the ITA 2000 to explicitly recognize ClickWAB contracts as valid. Secondly, various state acts must be amended to officially exempt stamp duty on digital consent mechanisms. Without these two critical fixes, our entire digital economy is basically operating on very, very shaky legal ground.
Which leaves us with this final, really provocative thought. Will the law evolve fast enough to protect your next digital handshake? This incredibly complex intersection of data value, legacy IT laws, and state taxation is something that desperately needs a public debate. Thank you so much for joining me on this deep dive in today's explainer, and I really hope it changes the way you look at the next I agree button you click. Catch you next time.